State Rep, Elaine Nekritz. Elaine, good morning to you.
Good morning to you.
Thanks for taking time out of your day for us.
Happy to.
All right, we got the Illinois Supreme Court preparing to hear the lawsuit over Senate Bill 1. There's a lot riding on this, is the understatement of the day.
I think that is an understatement, yes. For all concerned, actually.
And you were one of the key architects of this bill to piece it together, to push it through both the House and the Senate and get it signed into law. People know about pension reform. People have heard the phrase, and people know that this is what's pending in front of the Supreme Court. Before we dig into some of the legal details, give an overall idea, again, for people who perhaps haven't been paying close attention, exactly what SB 1, this pension reform bill, will do in the future for pensions in Illinois.
Sure. We have, at this point, about $105 billion of unfunded liability in our pension system, and that is rapidly increasing, and it's increasing the amount of our tax dollars that have to go toward the pension payment every year. And the result of that is it's crowding out other current state services that we I think would all agree need to be funded, like education and services for the mentally ill and the developmentally disabled. And so the goal of Senate Bill 1 is really try to balance all those competing demands and be able to afford all of them better and make it sustainable in the long run.
So you've got the plaintiffs arguing that it's unconstitutional because it violates the Constitution's pension clause mandate, meaning pension benefits not be diminished or impaired. And that's kind of what everything's riding on here.
It is, yes. And that is certainly the argument for the plaintiffs and the labor unions that have sued the state. The state's argument in response, and I think it is that there's nothing absolute about any constitutional clause or, frankly, the contract clause in either the U.S. Constitution or the state Constitution, and all these things have to be taken in context. And this is not a novel argument that the state is making. For about 150 years, courts have found that again, neither constitutional clauses nor contract clauses are absolute, and they do have to be balanced with other competing demands.
State Rep Elaine Nekritz with us. It's Riley and Scott here on WROK. The bill itself, the main part of the pension reform, the changes would be to adjust the COLAs, the cost of living adjustments, which right now are compounding each and every year 3%, and also adjust the minimum age at which some could retire and receive benefits. Are those the two main planks that are in this bill?
Yes, and I would say that the first one is really the most significant because that impacts both retirees, those that are already retired, and those that are still working. The retirement age really impacts only those that are younger and not close to retirement age. So it really is the annual increases. And I want to make clear that everyone knows that the checks that the pensioners are receiving today will never go down. It will in fact still increase every year. It will just increase at a slower rate.
And we're talking to you now because the lower court has already said they believe that it is unconstitutional. So now we head up to the Illinois Supreme Court. Why do you think the Supreme Court might find differently than the lower court?
I think those of us that were looking at this, again, on both sides, never really thought that the lower court, the circuit court, would do anything but find it unconstitutional. And so it was really always going to be up to the Supreme Court. And again, I think that the Supreme Court is in a position to be able to look at the complete picture and look at that not only the legal arguments that are being made, but also the fact that there are other competing constitutional demands that we're shortchanging right now in the legislature. And I would also say that courts, when these kinds of policy decisions, courts give great deference to the legislature because we are the policy-making body. We're the part of government that actually has to meet all these competing demands, and so they give great deference to the decisions of the legislature in this regard.
State Rep Elaine Nekritz with us. It's Riley and Scott here on WROK. Last year, though, the Illinois Supreme Court ruled that the Constitution prevents any diminishment for health care benefits for retired state employees. They said that was unconstitutional. What's the difference between this pending case and that one concerning health care benefits?
The question before the court last summer in the Canerva decision was whether health care benefits are considered a retirement benefit protected by the pension clause. And they decided yes. there's no question before the court right now as to whether the pension benefits that are impacted in Senate Bill 1 are part of the pension clause. We all acknowledge that they are. The question before the court now is what kind of protection are those benefits accorded? And that's a very different question. It's a completely different legal argument, and that's the legal argument that we're making about the absolute nature of the clause. And I just want to just to give you some other examples of why constitutional clauses are not absolute. And government regulates free speech all the time, whether it's obscenities, whether it's dangerous situations. We regulate the Second Amendment, the right to keep and bear arms in significant ways. So this is, again, not a novel argument that the state is making about the ability of government to regulate these kinds of things.
So in breaking it down with SB 1 in the pension clause, you're basically saying the pension clause is not a suicide pact with its absolutes. The other things that you had mentioned there bear consideration in the overall execution of it. That's
correct, yes. And several of the folks that submitted briefs along with the Attorney General on behalf of the state used exactly that phrase, that the Constitution is not a suicide pact.
State Rep. Elaine Nekritz with us. It's Riley and Scott here on WROK talking about Senate Bill 1, the pension reform law that will soon be before the Illinois Supreme Court. The phrase that pops up in some of the briefs is the police powers. What exactly does that mean? That basically is, in an emergency type situation where we're spending so much more than we can afford on pensions, there are some police powers the state might have. Is that about right?
Yes, and I also want, the police powers, again, is not a novel argument. This is something that courts have permitted legislatures to do and government to do for decades. And I think you hit the nail on the head. It is, the ability of government to balance competing demands and especially in emergency situations. And I think we could, with a completely straight face, argue that this is an emergency or a fiscal crisis. That, again, legislatures are accorded broad deference to make these kinds of decisions and balance competing demands. We still have to prove our case on that. Since the lower court just said the pension clause is absolute, and I'm not going to consider whether this was an appropriate act by the legislature, whether they went too far in making the changes that they did. If the Supreme Court says it goes our way and says that the clause is not absolute, I think they will have to send it back to the lower court to take some evidence and to make a decision as to whether or not the legislature acted appropriately in exercising its police powers.
So, in order to make the case that this is something that needs to be, this features, I guess, the extremes. You have to also paint the picture of what happens then should the court go, you know what? No, we're going to go along with the lower court here.
Well, we do, but we actually don't even get. If the Supreme Court says that the clause is absolute, we don't even get to that question. So, we're again hopeful that we will be able to put on our case as to what happens if this is not upheld. And a perfect example of that is we're spending, in the last fiscal year, we spent 22 cents of every tax dollar towards the pension payment. Most states are in the 4 to 5 cent range. So that's a pretty significant difference, and again, has a really great impact on all the other things that state government does.
And to be clear, we're spending a quarter out of every dollar, basically, and we are still 110, 20, 30 billion underfunded, correct?
That's correct, yes.
So if you start ramping that up, you see where the problems come in.
Right. It's a math problem. It's not anything beyond that. Yeah.
State Rep. Elaine Nekritz with us. It's Riley and Scott here on WROK. I know you're an architect of this bill. Do you consider SB 1 to be, to say a phrase, a final solution to the problem? Or even if SB 1 is upheld, do you think there is still more tinkering, more work to be done to put our pensions on a sustainable path?
I know that there are those that argue that it didn't go far enough, but I think that it still will be difficult for us because we're going to take that 22, 25 cents of every tax dollar and take it down to about 17 or 18 cents. So that still is much a little bit out of line with the rest of the states, but it's certainly much more affordable than what we are doing now, and the trajectory is better. We will hold at that 17, 18 cents, at least according to what the actuaries tell us, for the next 25 years, 30 years, and that won't increase right now, we would continue to see a larger and larger chunk taken out of every tax dollar toward the pension payment as we look into the future.
State Rep Elaine Nekritz with us here in another minute or two. I wanted to ask this to Dan Montgomery, who's IFT chief. He's been on the record in hearings and testimony saying, literally saying there is no pension problem. It's a revenue problem. Have you and your colleagues looked at all at what the tax rate in Illinois would have to be to raise the revenue needed to fund the pensions if SB 1 is struck down, and if Dan Montgomery gets his way and is right and says, hey, there's no pension reform at all, just a revenue issue, let's raise that revenue. What would the tax rate have to be to make it even remotely plausible?
Well, I think that depends on what your target is. I mean, if your target is to lower that 22% of every tax dollar to 5% of every tax dollar, that would require a very significant tax increase, and I'm enough of a mathematician to figure that out. But so it would depend on what your target is. Could we limp along for a generation and a half at 22, 23 cents of every tax dollar? Yeah, we probably could. But I don't think that bodes well for school children, for the cost of higher education, and for seniors trying to stay in their homes. So, I don't know how to pick a number for you. Mm-hmm. It would be depending on how we want to balance all those other costs that the state incurs.
And so this case has been expedited for the Illinois Supreme Court. When are arguments specifically, and when do you expect perhaps a ruling from the Illinois Supreme Court?
So the Attorney General filed her brief in support of the Senate Bill 1 on January 12th. The response from the labor unions, from the plaintiffs, is due February 18th, coincidentally the same day that the governor delivers his budget address. And then the Supreme Court, we don't have an exact date yet for oral argument. It will be either the week of March 9th or March 16th. And then beyond that, I make no predictions. I have no idea how long the court will take to make their decision.
State Rep Elaine Nekritz, thanks for taking time out of your day for us, and thanks for filling us in on the latest here.
Thank you. I appreciate the opportunity.